Hello and welcome to our webinar. Today's webinar topic is how to plan for your black sheep and your good kids too. I'm Debbie Faulkner. I'm the managing partner of Burke Faulkner Law. Burke Faulkner Law, we are a law firm in Oldsmar, Florida, and we specialize in estate planning and probate and also small business law. So we represent approximately 200, well, we've represented about, I guess at this point, probably about 300 different local companies as outside counsel. So we are specially situated to help with doing estate planning for business owners. But, you know, like with every estate plan, this comes with unique challenges, and that's what we're here to discuss today. I have a question. It's talking about the audio. I hope you guys can hear me. Can you hear me now? I hope that everyone can hear what's going on. In any event, I'm going to get started by talking about a will or trust and what the difference is. No, hang on. 1 second. Okay, so there are two different ways to have your estate plan set up. One way is to have a will, and one way is to have a trust. Both of those types of plans are plans to pass your assets and property on to the next generation. And so both a trust and a will accomplish your estate planning goals, but they do it in two very different ways. And this is important about how we're going to get to planning for your black sheep and planning for your troubled children, because really, if you have such a case, a will is not the way to go. So first things first, a will, we all kind of understand. A will leaves your property and your assets to your beneficiaries, to your kids in this case. You know, we're on here talking about our children. Leaves your property to your children at the moment that you die. A trust does not necessarily do that. A trust will plan for your property and your assets both during your lifetime and after your death. So if you are elderly and you become ill, your trust can plan for how you want your money to be spent on your own health and on your own self. Like, for example, whether you want to be kept in a nursing home or whether you want to be kept at home when you're elderly, you can provide for all that in your trust plan as opposed to your will, because a trust takes effect while you're alive. So you can basically set out exactly what you want your money to be spent on while you are here and you're maybe of advanced age and no longer able to handle your own affairs. A trust, there's other types of trusts. This type of trust that I'm talking about in this seminar is a revocable trust or a revocable living trust, or sometimes people just say living trust. Unfortunately, these are all the same exact document, but they have different names and variations. There is another type of trust that I'm explicitly not talking about here in this seminar, which is called a testamentary trust. A testamentary trust is a trust that is created through a will. So basically, I, Debbie Faulkner, in my will, I leave all of my stuff to my son in trust, and the trust comes into effect when I die. I don't recommend creating that type of trust because it creates both a probate administration proceeding and a trust proceeding after you pass away, which is a lot of extra cost and expense for your family. Although there are a lot of people who do this type of trust, that's not something I recommend because it is the most expensive way to leave your family money in trust. Okay, so if you haven't already, please subscribe to our YouTube channel so you can be notified of our other videos and webinars that we do from here on out. And if you have any questions, this is live, so please just throw them in the chat and I will respond to them as soon as I can. Okay, so with the basics of will and trust already kind of discussed, the only way to really plan for your family over the course of years or with any stipulations, which is what we're going to talk about today, you have to really have a trust. And so a trust is not just for the wealthy. This is something I constantly run into at the practice. People might come in and say, hey, another attorney told me that I don't have enough money for a trust. And that's just couldn't be further from the truth. A trust is just a different way of passing money to the next generation. It is not based on how much you have, it's based on what you want to do with that money that matters. And a trust is a little bit expensive to establish and set up, and depending on how much the funding process, how long the funding process takes. But if you have a child, a black sheep, or if you have a child who's married to somebody that you don't like, or a child with special needs, or you simply just don't want your heirs to receive a huge lump sum of money that they can blow right away, then a trust is for you. So I want to talk, about who is a black sheep and what am I referring to here. A black sheep can be someone in your family with a substance abuse problem. It can be somebody who's married to somebody that you don't trust or you don't like or don't feel that has your child's best interest at heart. It can be a son or daughter who simply marries and remarries like they change clothes and you just don't think that they would do the right thing with their inheritance. It could be somebody in your family who has a health condition that causes them to have to spend a lot of money on those things, and you want the money to be lasting for them interminably. Or it could be somebody that we more traditionally think of that is either wasteful with money, spends it on stupid things, gambling or some other addiction, or somebody who has a substance abuse or drug problem. All of these people, all of these situations exist. And in my 12 years of practicing, I think every family except one has had at least one person that fits one of these descriptions. So you're not alone, and it's not in any way embarrassing to have somebody that you need to pay just a little bit of extra attention to when you do your estate plan. So I will say at the beginning too, when you do have a family trust or a trust that is in your name that passes to your family members, you can create one trust document that ultimately creates different trusts for your different children. And that sometimes gets a little bit confusing. So let's say you come into me and husband and wife, and you want to create, you want to provide for your children equally in equal amounts, but you have some conditions or stipulations you want on the money for one child that you don't want on the money for another. One trust document suffices to plan both of those situations out. And what it ends up doing is after the second spouse passes away, then two kind of trusts come into being, one for one child and one for the other, that have different rules attached to the money. And that's so you really still only need one main trust to create different situations for different children. I see a couple of you have just joined us. Please subscribe to our channel if you get a chance, and you could be seeing all kinds of great content and material. Well, at least I hope it's great and that you learned something here today. Okay, so with respect to the differences in trust, so I'll tell you just an example of a couple that came in here recently. They had two children. One child was married at a young age to their high school sweetheart. They had 4 children together, and they're still married to this day, 15 years later. So the family has a very good relationship with their daughter who is in this condition, and their son-in-law, and their children, and they're very happy and have no reservations about that child receiving their inheritance or their money. On the other hand, we have another child who is recently engaged to somebody that the family does not know and has not yet had an opportunity to meet. And the spouse of the future spouse of their son is somebody that they're not really sure about. They're not sure if the marriage will last. They're not sure if that spouse will have undue influence and that sort of thing. So they obviously have different levels of concerns for one child over the other. In this case, we would want to think about obviously putting together a trust that provides that the one daughter who has a longstanding marriage, same children in common with her spouse, we can basically leave her money either with no restrictions or with limited restrictions. One thing I should say at the outset too about talking about the actual provisions of the trust is that you can provide in a trust for all of the inheritance money to be creditor protected, no matter if your son or daughter is perfect and you want them to have all their money at once, or whether you have a lot more stipulations on their inheritance. One thing we recommend, and we draft into all of the trusts, provided that our clients are accepting of it, is that we creditor protect it. So if your son or daughter caused a car accident, for example, right before they received a big inheritance, if we don't put creditor protection language in the trust, any inheritance they have a right to receive right away can be lost to the creditor. So we write language in there to protect that inheritance by saying that my son or daughter receives their inheritance in trust, and if they have any outstanding creditors, etc., then the money cannot be given to them at that moment in time. It's sort of a legal loophole that we draft into our trust so that if your son or daughter finds themselves in that situation or facing a divorce at the moment of divorce, something of that nature, that their inheritance is protected from that situation. Another issue that often comes up is whether the spouse of your son or daughter is allowed to receive their money, or if it becomes a marital asset as soon as you pass away. It does not. So even if you leave your son or daughter money outside of trust, if you leave your son or daughter the money outright, if he or she puts that inheritance into an account that is separate from their spouse and is always kept separate from their spouse, then their inheritance will not be considered a marital asset in the event of divorce. So it's something to consider when you make the trust. The advantage of keeping it in trust for your son or daughter is that they cannot commingle the money with their spouse, so it forces their hand, in a sense, to keep their inheritance money separate from their marriage. So if anything ever did happen in the marriage, your son or daughter keeps their entire inheritance. So that's one reason to also consider keeping it in trust over the long term. Okay, so now we talked about creditor protection. We talked about protection from spouses and protecting inheritances from bad spouses, which is a very common issue that comes across the door. Let's talk about a little bit more about, a son or daughter who has a substance abuse or gambling addiction. This is actually a little bit more common than you would think. With a son or daughter who is constantly facing alcoholism, substance abuse, gambling, things of that nature, the last thing you want to do is leave their inheritance to them in a lump sum distribution fashion. First, the sons or daughters that have these conditions are much more likely to have creditor problems down the road. They're much less likely to have the liquidity to deal with a car accident or the ability to pay their rent. They're just much more likely to end up in court over a variety of different issues, if not in criminal court, based on the fact that they have substance abuse or gambling addiction. There's a lot of tax ramifications that come into play and things of that nature. So the first thing is, what do we do in that instance? How do we leave them money? The first question you have to ask yourself is, do you want this child to receive the same amount of money that your other children receive? And at first blush, that may seem like an unfair question to ask, because most people, well, not most, a lot of people say that their kids should be treated fairly within their estate plan. But you've got to ask yourself, too, whether it is fair in the end if you have helped this son or daughter a lot more during their life due to their substance abuse issues or other problems that they have. Sometimes it kind of goes without saying, but when parents pass away and they've helped one child a significant more than the other due to these types of issues, it can cause a little animosity between your children after your passing. Some of these issues can be avoided by leaving equal shares or by leaving your estate in such a fashion as one child doesn't know what the other child gets. And that can be addressed as well within your estate plan. So the first question, like I said, is how much do you want to leave this child relative to the remainder of your children? The second question is, does this child or should this child receive an allowance that he or she can spend on whatever he or she wants? Or would you prefer for this child's money to be spent on their actual needs? So this is a little different when it comes to children that are not necessarily black sheep, but have an actual disability or have government benefit of some sort due to a disability. In that instance, we never can allow your child full reign over their money, or they would be kicked off of their government benefit. So we treat that a little bit differently. So I'm not talking about that here. I'm really talking about children that are capable of handling their own affairs, but that may not do the best thing with the money. They may use it on drugs or use it for a gambling problem and something that you don't want it to be spent on. So let's say that you have decided that you don't trust your son or daughter to spend that money in a reasonable and in a reasonable fashion and in a way that you intend it to be spent. The way to handle that is to have a third party trustee take care of this particular child's money for them. So a trustee is nothing more than kind of like a manager of the trust that you leave for the child. So a trustee has two roles, really. The first role is to invest and keep the money that you leave behind growing for the beneficiary. So typically, if you name a trustee that's not a professional trustee, they're going to hire a money manager just like you would when you have an IRA. So they'll hire a financial advisor of some sort, and that person will keep the money at least trying to grow for your child's benefit. And their second job is to decide, well, they have to follow the terms of the trust in terms of how much money they dole out to your child. Those instructions are what the trust is made of. That is what the trust provides, essentially. So you, with your attorney, draft the exact provisions that you want in the trust. Now, this is where a lot of people get hung up. They say, well, what can I do? What can't I do? That's a little bit too broad. I want the person in charge to have discretion. That's perfectly fine. Let's say you have a son that has a drug problem, but you feel like his aunt would be the best person suited to decide when your son needs money spent on for his benefit. You can write into the trust that the portion of my trust that passes to my son goes into his trust, and all the money is to be spent for my son, but the trustee has full discretion to determine when that money is spent and how that money is spent. We can also draft in provisions that say, if my son gets married, has a child, goes back to college or goes to college at all, goes to trade school, starts a company, the trustee shall consider giving him an additional lump sum distribution above and beyond whatever else we've decided to give him. So let's say we want your child to have an allowance, and the allowance is the income from the trust. So let's say you leave your son or daughter, $1 million. 1 or 2% of the trust is probably going to be earned as income each year, at least, probably more like 5%. But you can write into the trust that your son or daughter receives that income automatically, and that would be their allowance. If you don't trust your son or daughter to spend an allowance, then you can say that the trustee shall spend the income of the trust for your child's benefit every year. That could be spent on things like their health, education, maintenance, and support. That is a legal standard called HEMS standard, health, education, maintenance, and support. But what it really means is that the trustee should spend the income from the trust or the corpus of the trust, whatever you end up deciding, but the trustee shall spend money for their rent, on their electricity, on their pharmacy bill, on their health care. And if you don't want your son or daughter to be in charge, because you don't trust them, you can have the trustee basically required to spend that much money on your child's benefit, and the trustee would be responsible for writing the check to the landlord, would be responsible for writing the check directly to the insurance company for health care and things of that nature. If your child isn't in such a bad condition that you don't trust them at all, but you would rather them have some supervision with how they spend the money, you can also draft that into the trust. Let's say right now your son or daughter struggles with the drug addiction, but they've been clean perhaps for a year or two, and you want to acknowledge that your son or daughter is in a good place right now and give them some control over the money that you leave them. The best way to do this and to handle this is to have two provisions drafted in the trust. One is that your son or daughter can be co-trustee, serve in a co-trustee capacity with a third party that you name, and that your son or daughter and your co-trustee make all the decisions together, and that if your son or daughter disagrees with the other trustee, that the other trustee's decision governs. And all of that can be documented. Another way to handle it is to have your son or daughter essentially for a period of time, they can serve as co-trustee, and then after 4 or 5 years or whatever time frame you determine, if they maintain their sobriety and they do not get themselves in a financial turmoil, etc., then they can become the sole trustee. They can at one point assume full responsibility over their inheritance. But we can put stipulations that require that they reach certain standards or pass certain tests to be able to get to that position. Something that, to think about, really, one of the most important aspects of planning for a child that has a problem is who is supposed to serve as trustee. One thing I tell all of my clients, and I'll tell you the same, is you should not name one of your child's siblings to be in charge of their money. And if you think about it, it should be obvious why you don't want to do that. Like, siblings will go outside and will argue over whether the sky is blue or whether the sky is gray. And this situation becomes precipitously worse after somebody passes away. There's a lot of animosity or feelings or hard feelings or just hurt and pain that your children don't know how to deal with. And the last thing you want to put on one of your children is to be responsible financially for another child, and that child now hates your son or daughter that's responsible. There are professional trustee companies, and if you ever have any questions about who they are or what they do, I can provide that information to you. But suffice it to say, there are plenty of professionals that will do this on a fee basis, and that's what I recommend, especially for children that have ongoing problems. Not to mention that normally the responsible child in your family will not want to be fully responsible for their son, for their sibling, because it interferes with their day-to-day life. These services, these trustees do charge a fee, same type of fee that your financial management team charges you. It's usually a percentage basis, but I recommend it because it is the best situation for your family unity, for not causing any family drama down the road, etc. So that's a very important consideration to be making. If you guys have any questions, like I said, please go ahead and jot them into the live chat and I will answer them. Okay, so other provisions that you can put into your child's trust. So your son or daughter, maybe they don't have a substance abuse problem, they have a spouse problem. You just do not like who they married. They're caught up in too many things. I had a client recently who came to me, and the spouse of their son just spends frivolously, has taken out loans from his wife's family, constantly in debt. So in that type of situation, we're not talking about somebody backsliding into a bad habit. We're talking about an ongoing issue that's probably not going to fix itself unless there's a divorce down the road. In that situation, we want the stipulations to be a little bit different. The most important question is who is going to be in charge of that money, who's going to make the distribution decisions for that child. I recommend a third party because, like I said, it causes less problems with the family, and there are trust companies locally that are very good, and they are required by law to follow your exact instructions about when to give money to your child. But if you leave discretion in there, for example, I leave my money to my son in trust, and the trustee can make the determination as to when my son is going to receive money. But otherwise, then I want my son to receive 5% a year for the next 20 years, something like that. You can write things like that, where it is, your son does have an automatic right to funds over a certain course or period of time. But in the absence of that, you can also say the trustee has discretion to give him more money in certain situations. You can put a special stipulations that you that you prioritize education. If your sons or daughters are young, you can write language in there that you want all their money to be spent to educate themselves first. If there's anything left over after that, then XYZ occurs, that they get money 5% a year, or maybe the trustee spends it when the trustee decides it is a good time to spend that money. So a lot of times people get a little bit confused about what is off limits, like what can you not put in the trust for your child. There really is very few things under the law that you cannot write in your trust. One of those things is that you cannot say that this money is for my son or daughter if they divorce their spouse. So we just talked about that situation. You may hate your son or daughter-in-law, but you can't basically make that money pass only if they divorce that person. But you can tie it in trust, and by tying it in trust and putting another party other than your child in charge, you basically keep that greedy spouse from getting your money, from getting your child's inheritance. If your child has control over their own money, then their spouse essentially has control over that money too. Because if your child puts it in a joint account, it becomes marital assets. And if they don't put it in a joint account, but they're subject to a lot of influence from this spouse, they'll probably spend it in whatever manner that their spouse asks them to spend it if they are in charge of their own money. This is why I recommend, if you have any concerns about how the money is spent, that you spend time thinking about, number one, how do you actually want your money spent? Number two, how do you not want your money spent? What are your absolutes? Like, I definitely do not want money going to here or there. And number three, who do you think would be the best person to help make the discretionary distributions to your son or daughter for various events that might come up in life that are unpredictable? I guess that's pretty much what I wanted to tell you guys today. I want to drive home the fact that you have a lot of discretion of how you want to write these trusts. If you are concerned about a spouse, you're concerned about your business, you're concerned about your kid's car accident history, we can plan around all of those things. Your job is to come up with, how do you want your money spent? Or if you don't really care, you might care about what it is not spent on. And then who do you think would be a good person to take charge and make the distribution decisions for those unforeseen circumstances that come up in life? And so I'll leave you with that. And if you have any questions or concerns or thoughts that come from this seminar, please feel free to reach out and email me at Debbie@BurkeFaulknerLaw.com. That's DEBBIE@BurkeFaulknerLaw.com. Or you can also email us to ask for a copy of this webinar, which will also be posted on our YouTube channel. Thank you all for signing in today. I really appreciate it. Have a safe and happy weekend.